Well, this is Steve Carlson. It's 2 days before the scheduled election contest trial before a panel of three Ramsey County Court judges on the 18th. These are appointed by the Chief Justice of the Minnesota Supreme Court according to Minnesota statutes for congressional elections. Now, the power on this, the only ones authorized to judge any conclusions of law or findings of fact is the U.S. Senate itself. And that is according to Article 1, Section 5 of the United States Constitution. So I am filing an amended contest. I've already served it on Senator Franken and Secretary Ritchie, and I filed it with the Ramsey County Court, civil filing. And I want to just explain why I did this. Basically, this contest is and always has been directed to the Senate. But the way many contests are written in Minnesota, they're mostly for non-congressional elections. And you have to establish certain procedures within the state law of Minnesota. So this one is rewritten to direct it to the Senate. So basically, I have moved the panel to adopt this amended election contest. First, to specify the sections of U.S. Constitution Article 1 on which this contest is based to the U.S. Senate. Two, for purposes of clarity, correcting some typos, and also numbering sections according to the answer of the Secretary of State who complained that every paragraph should have been numbered. Three, to clarify some of the allegations discussed by Secretary Ritchie. In particular, he was found by the legislative auditor of using at least 600 voter email addresses and donor email addresses that he took home from the Secretary of State's office, where he was the Secretary of State, to use to raise funds for his Secretary of State's campaign. Apparently, these addresses are also being sold. Apparently, people are getting millions of dollars, and he is stepping up hard, has stepped up hard against me since late in the 2012 election, after Betty McCollum complained that people were using voter email addresses to campaign against her, and I was campaigning against her at that time. But the 12,000 that I mentioned in the unamended complaint, that's a number that was on his email distribution list, but it's unclear how many of those he actually took home from the Office of Secretary of State. And four, inserting references to the United States Senate to which this election contest against Senator Franken is directed, to make clear that it is directed to them and that it seeks a resolution. Senate file such and such a resolution dealing and disposing with this contest which I am raising. And just a tiny bit of discussion. The Senate contest challenged the manner of election of candidate Franken and of the results, which not only would return him to the U.S. Senate based on, I alleged, an election full of great irregularities and serious material and deliberate violations of Minnesota elections law, including the U.S. Constitution, but also would wrongfully deprive, based on the irregularities and violations, the independent voters of the state of Minnesota, of the vehicle of the Minnesota Independence Party, which has, as a major party, given them, including me, a spot directly on the general election ballot. Since it is highly unlikely that if the laws and constitutions were followed in Franken's election, my election, and are to be followed in the future, not this election only, the vote of the Minnesota Independence Party voters and supporters will rise, and the turnout will increase due to having a genuine and not a sham election. Al is great at show business, and it was said that he was a Zen master of boredom in this election, that he was terrified of making a mistake, so he was kind of just treading water. Well, that's not what the Constitution calls for. Now, it is was always understood that this elections contest presented according to the Minnesota election laws is directed to the United States Senate, pursuant to its power under Article 1, Section 5, to judge the elections, returns, and qualifications of its own members, and also under Section 4, that, quote, the Congress may at any time by law make or alter such regulations, unquote. That is, regulations of the manner in which the states conduct their election. And that in accordance with Minnesota Statutes 209:12 and Article 1, Section 5 of the U.S. Constitution, that body would consider whether the allegations brought and backed by the evidence to be received here rendered the results less valid or wholly invalid. The issue I wish to bring before the U.S. Senate is not only to exclude Senator Franken, but to judge the validity of and the manner in which the election was held, and pronounce on whether this manner is consistent with the U.S. Constitution and its amendments, including the 1st, 14th, 15th, and 19th Amendments, which the Congress itself drafted, in which Senators Franken and Klobuchar intend to redraft in light of the Citizens United decision. That's the First Amendment. The amendments in the amended contest have spelled this out more clearly and otherwise clarified, corrected as far as typographic errors, and organized the document for greater ease of use by the parties, the panel, and the U.S. Senate. So just a little bit of the feel, its name now, the Amended Election Contest and Request to the United States Senate for a resolution arising from the statewide election contest on the 2014 U.S. Senate race between Minnesota major party nominees, Senator Al Franken, DFL, Mike McFadden, GOP, and Steve Carlson, Minnesota Independence Party. And 2, the question voted on statewide, specifically, shall the Minnesota Independence Party be delisted as a major party in Minnesota? And just want to deal with this issue of qualification. Now, as originally submitted, the word qualification, small q, was used in a number of contexts. Now, because it has a special technical meaning to the Senate itself with a capital Q, I don't want it to be confused. This first sense, which was citing Yarborough, ex parte Yarborough, is really, I think, the most important sense. This is ex parte Yarborough from 1884, which talks about Congress's right to regulate and to judge the qualifications of candidates by judging the qualification for the voter. If that qualification for the voter, as I allege here, is not met, then that undermines the quality of the Senate. So, and I think this, I'm not sure if this was a Senate race or a representative House of Representatives race in Georgia. That's where Mark Ritchie is from. Brings some baggage, I guess, from that state. But I'm not sure whether it was for the House or the Senate. But what they're saying is the Senate cannot be just a collection of people that are kind of agents of various states which don't follow the federal law. And that's what that case is all about. What they were doing was beating up voters who wanted to vote in the Democratic Party, I would imagine, because they were black. They didn't want them to vote, so they brutalized and intimidated them so they couldn't vote. So that's what that case was about. Now, what this case is about is the same thing, because we're talking about where is the right to vote located. And this says it's located in the Constitution. And then not only where is it, but what powers of the federal government grow out of that right to vote being enshrined directly in the Constitution. Now, I don't mean the First Amendment or any amendment. It's in Article 1, Section 4, the one that I am basing this contest on. Let me just read here. This is from Ex parte Yarborough, written by Judge Miller of the Supreme Court in 1884. And he says that the U.S. Constitution adopts the state, in this case the state of Minnesota qualification, as the federal qualification for the voter. And this is the most important idea of qualification for me. Now, a voter who is qualified now is in a position, as our government is constructed, to decide whether or not that candidate that he may or she may or may not vote for is qualified to get their vote. And that's really the most important the meaning of qualification in this test. And they cannot determine who is the most qualified voter if they don't know anything about it. So the qualifications of the candidate now come in, and that the link there is information, communication. This is enshrined in the First Amendment, the freedom of political expression, freedom of political association that have been trampled on by Al Franken to make this a show business and a sham election, not a genuine election that meets the standards of the Constitution. And also, the way that Mark Ritchie has been conducting elections, he's driven the turnout way down since he was elected to that office. And I think if he wouldn't have been taking the emails home to campaign for himself and instead had pressed forward with some of his ideas, not as self-serving enterprises, and suppressing the First Amendment in the elections that he supervised as the chief elections officer for Minnesota, also one of the top officials in the Democratic Farmer Labor Party here, I think that we would have seen the turnout go up, and we would have seen far better campaigns, more interesting campaigns, and it would have been very, very helpful in this critical time in American history. Okay, so the Constitution adopts the state qualification as federal qualification for the voter. But his right to vote is based upon the Constitution, the voter's right, and not upon the state law. And Congress, therefore, has the constitutional power to pass laws for the free, pure, and safe exercise of this right. This election was not free, it was not pure by any means, and I'm contesting it. So I don't want to go through this whole contest again. I have that in 3 parts already at my YouTube. I will say that the qualifications here in Minnesota is that anybody can vote who's over 18, lives in the precinct. It's stated in the Article 7 elective franchise section 1 of our Minnesota Constitution. This is what they're violating by excluding these people from the precinct caucus if they don't agree that a majority of women have to make every decision, that there's going to be race quotas, gender quotas, sexual practices quotas, and that the straight white male participation is limited, therefore, to 35%. So people are necessarily disenfranchised from their vote. That they're abridged, they're denied. It violates the 15th Amendment when you do it on the basis of race, and it violates the 19th Amendment when you do it on the basis of gender, as well as the First Amendment. And so I just wanted to talk about how qualification now means. Of course, I've referred to wanting to get my positions, arguments, and qualifications for U.S. Senator before the voters, and that this was consistently blocked, basically blacked out by Al Franken. A lot of the voters would not have known I existed until they looked at the ballot and saw my name at the top, because the great job of just getting everybody inconvenient out of the way, including Adrian Peterson. Al Franken, Mark Dayton said Adrian Peterson was an embarrassment during his campaign, and therefore was benched immediately. And it's telling that it was on election day that they went ahead and tried to settle that down in Texas. That's when Peterson's lawyer, and they understood that if they tried to do that during the election, Al Franken was going to make a big case out of it. Al Franken talked more about Adrian Peterson and more directly about Adrian Peterson than any other issue in this race, because everything else he was on the defensive from Mike McFadden, who said defend yourself for being 97% with Obama, Mr. 60th vote, on your vote on health care, on financial regulation, just all the way down the line was just backing up, the Democrats led by Obama starting in 2008. They waited 5 months for that 60th vote and then finally put that through the Senate. It had already been, I believe, passed in the House in 2009. Anyway, it's a sordid history, and they're still fighting it out in the Senate. They had to wait for Al Franken, and this all happened in 2009 to get it through in the Senate. So I want to be very specific because we're talking about previous cases of the United States Senate and the House of Representatives from the U.S. Supreme Court and from the District of Columbia Court, including the Morgan case written by Justice Antonin Scalia when he was a circuit judge, I believe, there, addressed this issue of qualifications. And the technical term that it has is from this statute, which is specifically the which gives them the sole judging power. And specifically it means in that they need to be like 30 years old, from the state, etc. But the qualifications I'm talking about is the qualifications of having been elected in a constitutional manner, and one that meets all the regulations, including the Constitution, that are upheld by the U.S. Senate. Now, I won't argue that every senator is following the First Amendment. I know that this quotas practice, which violates the 15th and 19th Amendment, is practiced in California, in Texas, probably New York. I haven't gone through all of the states, but in those those Democrat parties, not in Illinois, I know that, but in most of these Democrat parties, they're passing legislation to create gender quotas for women, and so that they have to be at least 50%. California, there need to be about 12% for homosexuals. Okay, in Texas, there need to be 10% homosexuals in order to seat that delegation all the way up to the Texas State Democratic Convention, California State Democratic Convention. And Barack Obama has said that's very important to him as he was running in 2012. So you can see it's important for him to skew the composition of the voters in the Democratic Party. And I want to get this out. I think most Democratic voters would not support this. They knew that all decisions were being made by a majority of women, and that you had to limit straight white males to 35-40% of the vote. I believe in California, like 23% of the Democrat delegation has to be Hispanic. Now, I would be very pleased if we could reach that proportion in California in the Democratic Party through normal give and take and exchange of ideas, which the First Amendment requires, and freedom of association within the Democratic Party. But here in Minnesota, one of the things I'm complaining about is that the state actually makes this a legal requirement that if you don't agree with this, what they call it a principle, you cannot participate. It's a basis of participation. Now, Mark Ritchie says there's nothing that kept me from coming to the DFL and campaigning, but what I'm saying to Mark Ritchie is that my potential voters among the delegates all the way up to the state convention, which I would have loved to campaign to the DFL if it was open, would be limited. White males, straight white males, would be limited to 35%. First of all, I oppose that. Secondly, you start horse trading among the candidates to make sure you get the horses that are this color, that color, this gender, this sexual practice or whatever. All of a sudden you don't have an election anymore. All of a sudden you don't have a party anymore. Basically what they're just doing is lining up constituencies, special interest constituencies, behind each of the special interest issues they're going to push all the way to the National Convention. And so, attacks on marriage, attacks on civil rights, on people being equal, having equal opportunity, rather than getting rid, telling white males that, you're on the wrong side of history, we're waiting for the old white people to die off and stuff like that. We cannot have elections like this. So we have to have open elections. That's my goal here. And so that is the basis of this amendment. I'll have much more to say. I'm going to be in a trial. I believe there'll be oral argument starting on Thursday. It has to start within 20 days of when the declaration of Franken and the decertification of the IP were made. And Mark Ritchie did make that declaration to a reporter in my presence that because the 5% was not met, unless there was a discretionary challenge to that count, that the IP, Independence Party, is going to lose its major party status. And this contest challenges that. I hope that you pay attention to that, because this is a strong structure for independent voters. 58% of American voters want to have a third party, not Democrats, not Republicans. And yet this duopoly, they're like dead set against that. They're doing everything they can to stamp out any vehicle which would empower those independent voters. I was just reading this book here. Here's a man from the 4th District, Eugene McCarthy. This is a book written by Dominique Sandbrook of Oxford, I believe. But in this book, I learned that this nonpartisan league in western Minnesota was something that Eugene McCarthy loved. And the people there in Watkins, Minnesota, loved this. And it helped to create third-party movements in Minnesota. And so we've got the independent Republicans, we've got the DFL itself, which bring together coalitions. So we've got to keep this tradition alive, and I certainly hope that in this proceeding that we will protect the rights of the independent voters in this state. I'm Steve Carlson, and I hope that you continue to watch this. I know this is getting a little long for now, and please look at some of my other videos to learn more about this contest. And I've got the interrogatories out there too, which I've already served on Al Franken, on Mark Ritchie, his secretary. Mike McFadden's not involved in this. I've served interrogatories on his counsel, Burt Black, and on Nancy Bream, who kind of started all this when she very enthusiastically told all candidates in 2010 and 2012, be aware that you can order these email addresses of the voters. And everybody was apparently doing it. But she said that she's been doing that for years, but when it got to me and Betty McCollum wanted this to stop, all of a sudden, boom, Mark Ritchie and Burt Black came in, and here we are 2 years later, trying to bring this to the United States Senate and get somebody to pay attention to restoring the purity and the freedom of Minnesota federal elections. Thanks.